And joining me now is Joshua Ritter. He is a criminal defense attorney and a former Los Angeles County prosecutor. Josh, I wanted to talk to you about the criminal liability factor because that hasn't been a big focus as of yet. But as I read into statute, if you flout industry standard in, the prosecution of whatever it is you do to sell tickets to the public, you become at risk for exposure to criminal prosecution if there's a disaster like this, regardless of the fact that Stockton Rush was a passenger on his own vessel and truly believed in the safety. What do you think is the criminal exposure for OceanGate, the company, and also the employees who may have been involved in building this?
Two things, really. One, if there was any kind of fraud or misrepresentation of the safety of that vessel, purposeful misrepresentation of the safety of that vessel. I understand that there were waivers signed, but if you're not explaining to people the actual risks involved and you're misrepresenting those risks, perhaps in the pursuit of some sort of financial gain, that can be very problematic to the point of criminal. And the other thing is if there was some sort of cost-cutting measures taken. We've talked a lot about the materials that were used, that those aren't traditionally used or should not be used in submersibles. And if that was a reckless indifference to the safety and welfare of others, then yes, that can extend into the purview of criminal liability as well.
So, Joshua, as I understand the way it works, prosecutors do a lot of weighing and balancing whether to go ahead with a prosecution, not just whether they have the goods, but whether they think they can actually get a conviction. And when Stockton Rush himself, as the CEO, went down with these clients, would that not make it very hard to convince a jury that there was any kind of recklessness or even negligence on behalf of the company?
Yeah, absolutely. I mean, if you're talking about what points would a defense make, obviously he's not going to be a defendant if this ever sees the inside of a criminal courtroom. But other parties involved, that would be one of the first things that they would point towards is, look, even the designer, the owner, the person who was operating this was riding along in that vessel because he felt so safe about it, because there were no cost-cutting measures taken, all of those points that I tried to make previously. But again, it's going to really come down to what was disclosed to these people. Did they have a really true understanding? Was some sort of misrepresentation, and not just a mistake, not just an underestimate, not just a bravado or confidence in their vessel, but was it purposeful? Were they trying to deceive people? Or were they just so indifferent to the risk? Were they just so in their pursuit of exploration, did they put aside all of these cautions? In that clip that you showed earlier, he seemed to have this kind of bravado about the idea that others have advised not using these kind of materials to build a submersible. Well, I didn't listen to that. Well, that's a huge statement to make, that you knew that this was problematic to use these type of materials and you ignored that. Does that extend into reckless indifference? I don't know. And were others aware that he was making those kind of comments, perhaps to people who were purchasing tickets to be on board that vessel?
Well, explorers have never been known to be modest, and it is why they are who they are, and it's why they achieve, what they achieve is the other part of the whole equation. Joshua Ritter, thank you so much for being on tonight. Really appreciate that.
Thank you for having me.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.